Jim Thurber. I'm the director of the Center for Congressional Presidential Studies. This is, we've had over 300 panels since the founding of the center, and this is going to be one of the best. And if these people were at an auditorium at NYU or something, it would be packed. And so I'm sorry we don't have more people here. There's so many events going on in the spring, it's tough. But we have presidential and constitutional scholars here to talk about the Obama administration and war powers, legal issues involving the use of military force. I want to introduce each of them and say a bit about what they're going to talk about. Then we'll start. We'll have plenty of time for Q&A at the end. This is on the record. It's being recorded so that we'll have a site where people can go and get further explanation that you cannot write down now, because several of you are writing papers on this topic. Let me begin by thanking Chris Edelson, who's really the organizer of this. It was his idea, and he organized it, and I appreciate it very much.
Oh, my pleasure.
Bringing Lou and Shoon here. He's a presidential scholar here at American University that's very well known for his teaching, but also for two books. The most recent one is Barack Obama and Limits on Presidential National Security, right on the topic, as well as his first book, both University Press books, Emergency Presidential Power from the Drafting of the Constitution to the War on Terror. Lou Fisher, to my far left here, I've known since 1973. I was a teenager then. No. He was working on the Budget Impoundment Control Act, and I was too. I was working for Senator Humphrey then, and you don't remember this, but I went up to this little hovel at the CRS where you were, a desk with books all over, and we've been friends ever since. And he has written a remarkable number of books, 24 books, many of them award-winning, a basic book on constitutional law that law schools use that has made him very wealthy. That's why there was that's why you had a limo that brought you here. 500 articles, and he had 4 decades, distinguished decades, at the Library of Congress as a constitutional law specialist, separation of powers specialist, and he's moved throughout constitutional laws in his writing up there. And Shoon Murray, my colleague at the School of International Service. Those of you from off campus, we have a weird setup at American University. We got a whole bunch of scholars in political science in 2 schools. If we put them all together, we would be much better known. But we reach out and we work with people from the School of International Service, a couple of colleagues that are here. She's the author of the Terror Authorization, the History and Politics of the 2001 AUMF, and also Mission Creep, the Militarization of Foreign Policy with Colleagues. She's written about the use of powers in counterterrorism. Now let me tell you a little bit about how we're going to do this. I told them I'm limiting them to 5 minutes. They're used to 55 minutes, you know, in a regular class. 5 minutes, and they're going to talk about some very complex things in 5 minutes. The theme of the panel generally is ways in which the Obama administration has acted without regard to constitutional or statutory limits in the use of military force. It's a biased panel, okay? If you take all of our panels for several years, they all even out. We get all kinds of views. This one, you've got some distinguished scholars that are questioning the constitutional and military constitutional rights and statutory rights of the president. Basically, it's about why has Congress been differential to the president on these issues, and they'll talk about them. Lou's going to begin, and Lou is going to talk about, quote, the illegitimate use of military action without congressional authorizations, giving you a little history of it, maybe all the way back to Truman to present. Chris Edelson will go next, and he's going to be explaining Obama's failure to break with Bush. You can see there's a theme here. Okay, it is really pointing out what he has, what the president does. Failure to break with Bush on his military policy. Shoon will be talking about the use of force against ISIS and the justification for it, but also legal and constitutional, but also the background of it, and also about drones, a very important topic. We have killed a U.S. citizen with a drone in Yemen without having a trial. It's somewhat controversial with a lot of people. I think she'll address that. So let's begin with Lou.
Okay, I prefer to stand up.
And we do not have a mic to project, so we need to project a little bit.
Okay. So, from 1789 to 1950, presidents came to Congress and using military force against another country, either to get a declaration of war or to get a statute. The first war we got involved in, the Quasi-War in 1798, was by about 20 statutes. So Congress has always had the option to either authorize war by statute or to declare it. And that was the constitutional way to go. But from 1950 to the present time, we have been acting unconstitutionally and illegally by presidents not going to Congress, but instead looking for authority from either the UN Security Council or from NATO countries. And I'll explain why I think that's full-fledged illegal, unconstitutional. So in World War II, there was a recognition that we needed a world body. There had been a League of Nations, and we didn't join the Treaty of Versailles, and everyone knew that Congress, because of that experience, had to have a central role. So when the Senate was debating the UN Charter, President Truman was in Potsdam, and he cabled and put into congressional records, so it's a public statement. And Truman said, I want you to know if I ever use U.S. troops in a UN military action, I will come to Congress first and get your authority. So, public statement. Not legal, just a personal pledge. The Senate passed the UN Charter, and the UN Charter has language saying that the Security Council wasn't going to have any troops or anything like that. They depend on member states for that. And the UN Charter says that member states will give troops, equipment, etc., assistance in accordance with the language's constitutional processes. That's in the UN Charter. So every nation had to decide what's our constitution, how do we do it? So Congress had to do that. And what Congress did was to, in both the House and the Senate, had to be a statute which would declare what our constitutional process is and how do we implement the UN Charter. And held hearings and reported out, and it's called the UN Participation Act, passed in December 1945. And it goes to President Truman. He signs it. No objections. You know, sometimes the president will make a signing statement. No objections. So we have a law that says that under the UN Participation Act, under Section 6, that if a president wants to use U.S. troops in the UN military action, he will come to Congress first and get legislative approval. So that's the law. 5 years later, I'm sure you know, then June 1950, President Truman goes to war against North Korea, never came to Congress. And you can say, which would be legitimate, it's the fault of Congress not to react and say, you just violated the law. And I think the best explanation, not a good one, is that you're fighting the communists, North Korea. And a few members of Congress did challenge, but they were few. So that was a precedent. And even though it was an illegal precedent, even illegal precedents, once established, become a precedent for future use. And that is what happened under President Clinton. Never came to Congress for all his use of force. Twice he went to the UN Security Council to use military force against Haiti, and then later against Bosnia. He went to the Security Council to use force against Kosovo. He couldn't get authority from the Security Council, so he goes to NATO members, and they authorize it. So now NATO members and Security Council become a substitute for Congress constitutionally. So that's what has gone on. And most recently in 2011, I'll talk about this later in our panel, President Obama decides to use military force in Libya, never comes to Congress, goes to Security Council. He gets a resolution that only authorized military force to protect civilians in Libya. That's what the resolution authorized. But instead, once you take that step, you now are in a position to be in Libya with allies, particularly England and France. There were rebels. We don't know one rebel group from another, but we were not supposed to work with rebels. That was out. That was not authorized by the Security Council. But pretty soon we're working with this rebel group and that rebel group. And it starts to escalate, mission creep, and pretty soon it's now regime changed to get rid of the leader, Gaddafi. And he was killed. So by the use of force, we got rid of a leader as we got rid of Saddam Hussein and left a country that's broken in Libya. It's a breeding ground for terrorism. And some months back, Tom Friedman of the New York Times interviewed President Obama, and Obama admitted that what he did in Libya was a mistake. You don't go in and get rid of a leader and walk away, which is what we did, and leave a vacuum there. So you would think any administration, not just President Obama, but anyone around him would have enough knowledge to say, if you're going to take step one, you ought to know what the next step is. And we didn't do it. That's not the first time. We've done it many, many times. So there's an unconstitutional, illegal action. I'll just stop with one comment. Walter Jones has been in the House for many, many years from North Carolina. And he has a resolution stating that any president who avoids Congress by going to the Security Council for, quote, authority is creating an impeachable act. And I just think that's a very nice thing to have on record. We forewarn you that if you do it, it's impeachable. Now, I'm afraid if it ever were done, nothing would happen. But I think it's a constitutional step. If you do this, it's impeachable. And I hope any president who did it would be impeached and removed. Thanks.
Resolution passed?
No, it hasn't been acted on yet.
Thank you, Lou. We'll get back to you for further remarks, but also Q&A. We're going to go to Shoon next. I gave you the wrong order, and then we'll end with Chris. Shoon.
So my comments are very much in line with Lou's, except I'm going to talk about a current event, which is the war with ISIL, and how the 2001 authorization for the use of military force fits in with that. As you know, the war with ISIL has been going on for 10 months. It has not had explicit congressional authorization. The president did send a request for an ISIL-specific authorization for the use of military force in AUMF, which has been stalled in Congress. But he says he doesn't really need it. He can act without it. And he can act without it, he says, because there are two prior congressional authorizations, one from the 2002 AUMF for the war in Iraq, under very different circumstances, and also the more important one, and the broader one, and the one that I'm going to focus on today, the 2001 AUMF, which was passed 3 days after 9/11. So you have three moving parts here, three AUMFs. One which is a draft that's up on the Hill now, and two prior ones. And the one that I'm going to focus on most is the 2001. I'm going to make 3 points. When the Congress passed the 2001 AUMF, it had a narrow view of its targets. The second point would be that ISIL does not fit this statute. And then the third point would be that Congress needs to step up and enact an ISIL-specific AUMF, or else it'll see its congressional authorities even more encroached. So let's start with the first. That Congress did not mean to pass a long-term, decades-long, broader war authorization for the president to go after a wide range of terrorist groups in that initial authorization in 2001. Listen to the words of the authorization itself. It says, "The President is authorized to use all necessary and appropriate force against those nations, organizations, or persons he determined planned, authorized, committed, or aided the terrorist attacks on September 11th, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons." There is a nexus to 9/11. It means Al-Qaeda and the Taliban. Those are the targets. And if that's not enough, consider the language that Congress rejected at the time. The White House sent a draft, and Bush White House sent a draft in 2001 with much broader language. In that draft, it said that they wanted the words that the President could deter and preempt any future acts of terrorism or aggression against the United States. Now, that would allow an ongoing war authority against terrorist groups, but that was rejected. And you also have statements at the time from key leaders. So then Senator John Kerry said that on the Senate floor when the 2001 was being passed, authorization was being passed, he said that it does not give the President blanket approval to take military action against others under the guise of fighting international terrorism. And the late Robert Byrd put into the congressional record, he said, "The use of force authority granted to the President extends only to the perpetrators of the September 11th attack. The intent was made clear when senators modified the text of the resolution proposed by the White House to limit the grant of authority to the September 11th attacks." I harp on this issue because I think it's clear, the case is clear, that the Congress meant for that authorization to be for Al-Qaeda and for the Taliban, not a broad, long-term new power for the President to take on other terrorist groups. Which brings me to my second point, how does it fit with ISIL? Now, it is true that the Obama administration has already stretched the 2001 AUMF to cover associates of Al-Qaeda, under the logic that you could cover co-belligerents. And they've used this logic to extend the scope of the 2001 AUMF to groups such as Al-Qaeda in the Arabian Peninsula. Now they are trying to broaden it to include ISIL as well. But the problem is that ISIL doesn't fit well with this logic because ISIL is not a co-belligerent of Al-Qaeda, nor was it around when the attacks happened on 9/11. So it's not a good fit to this. Now, the administration would argue, but we had fought an earlier incarnation of this group in Iraq. And they would argue that this group wants to be the successor of Al-Qaeda. Or they'll argue that there are associates of Al-Qaeda who have pledged allegiance to ISIL. The problem with this is that if you take this, then the scope of the AUMF becomes very broad. Does that mean that you can be an associate of Al-Qaeda and be covered? Can you be an Al-Qaeda wannabe and be covered? Can you have past connections which make you covered? It broadens the scope such that this will be around for a very long time if it is accepted. Which leads me to my third point. It's very important that Congress not accept this logic and then act, although unlikely as it is. I understand that it's unlikely that they'll act, but it is important that they act. Because if they don't act, just as Lou said, it sets a precedent that the 2001 AUMF can be used for other kinds of conflicts. And this was not the original intent, and it would act it does take away the war powers of Congress, by Congress's own deference, but it will take away the war powers of Congress. Thank you.
And we'll continue with Chris. He's going to explain the continuity between Bush and Obama, which we've talked about a little bit, but why did it happen? Ultimately, all three of you and others will address the question, well, why does Congress give up all this power? Why are they deferential? But Chris, go ahead.
Yes, an essential question. And so I'm glad to hear what Shoon and Lou have to say. I think they're right on target. I'm a lawyer by background, so precedent concerns me, even if it's illegal precedent, illegal precedent, as Lou says, because we know that illegal precedents get followed. Lou has submitted an amicus brief in a case I'll talk about later, I think the Zivotofsky case, including one of these terrible precedents. It's not even really a precedent, but it's dicta that's become precedent involving the sole organ doctrine. Shoon's right, of course. The key is getting, and Lou mentioned this too with Representative Jones, the key is getting Congress to step up. It may be unlikely, but I'm going to give a little bit of promising information about that. So let me start, though. President Obama, of course, is a lawyer too, and when he ran for president in 2007, he was asked, there's this tradition since Korea. It's an illegitimate tradition, but a tradition nonetheless. And it was continued, and I think in some ways even expanded by President Bush. So President Obama's running, he's then Senator Obama running for president in 2007. He is asked by Charlie Savage, a reporter then with the Boston Globe, what do you think about when presidents can use military force? Senator Obama's response was right on target at the time. He said, Obama, the president does not have power under the Constitution to unilaterally authorize a military attack in a situation that does not involve stopping an actual or imminent threat to the nation. The president can only act unilaterally during an emergency when the United States is attacked or imminent attack and there's not time to consult Congress. Those are my words, the second part. Continuing with what Obama said, as commander-in-chief, the president does have a duty to protect and defend the United States. In instances of self-defense, the president would be within his constitutional authority to act before advising Congress or seeking its consent. Self-defense context. Obama continued, history has shown us time and again, however, military action is most successful when it's authorized and supported by the legislative branch. It is always preferable to have the informed consent of Congress prior to any military action. So, Senator running for president, Obama describes exactly what the framers conceived of, a scheme where Congress had the war power. In an emergency, the president could act. Very limited. This is clear. Some of the records for the Constitutional Convention are not clear. This piece is clear. The framers, when they created the Declare War Clause, said we want to reserve power for the president to repel sudden attacks. So Obama's right about that as candidate. As president, unfortunately, he doesn't follow that approach. In Libya, in Syria, against ISIL, as Shoon mentioned, he's either claimed the authority to act unilaterally, just under the Constitution or under past practice, or, as Shoon mentioned, has implausibly suggested that existing statutes give him authority to act. One hopeful example, though, in 2013, President Obama is prepared to order military action against Syria. The Assad regime, there's evidence it's used chemical weapons. Obama says, I'm going to act. It looks just like Libya, which Lou mentioned before in 2011, where Obama had acted without congressional approval, relying in that case on a UN authorization, which is not legitimate. In Syria in 2013, there wasn't even the UN authorization. Not that that would help under US law. But this time something was different. Members of the public contacted their representatives in Congress, and about 150 members of Congress signed letters to President Obama saying, as Representative Jones has suggested in his resolution that Lou mentioned, you have to come to us first. You have to seek approval. And President Obama did. He submitted proposed legislation to Congress. It was never acted on. And this is interesting to me, too. The argument was we have to act quickly. Critics of the time, John Yoo was a lawyer in the Bush administration, Office of Legal Counsel, said Obama's making a huge mistake here. The regime in Syria, the Assad regime, will know what we're going to do. We have to act quickly. We're missing a chance by going to Congress. They're going to delay. The delay actually helped in this case. It opened room for diplomatic resolution. The need for military action against the Assad regime in Syria never materialized. There is action against ISIL now in Syria. That's a separate matter. So Congress has shown it is capable of asserting itself, which I think is important. The question is how to get that to happen in other circumstances. And the problem here is basically power and limits. Everyone acknowledges the president, like the framers pointed out, the president does need power to act in some circumstances, in an emergency, when Congress can't act. When Lincoln acted during the Civil War with Congress out of session. The problem is there need to be meaningful limits on presidential power. And the problem since Korea, as Lou mentioned, and continuing, I think even to some extent getting worse since September 11th, is presidents have acted without meaningful limits, without meaningful constitutional limits, without meaningful statutory limits, because, as Shoon pointed out, they are willing to stretch the language of statutes beyond their reasonable meaning. President Bush did this as well with the 2001 AUMF in different ways. So that's the problem to consider. The Obama administration promised to move in a new direction to set limits. I don't think it has, unfortunately. The question is how to get that to happen.
So we have a highly partisan Congress. About 2% of the people vote together, according to the Common Vote analysis. It used to be about a third in the 70s, early 80s. It's gridlock. I have a new book coming out, American Gridlock. I'd like you all to buy multiple copies about this. But lately, we see the blossoming of, theoretically, of bipartisanship. Now, do you think bipartisanship is blossoming in the area of checking the president on war powers, but also on foreign policy? What's happening right now?
Not in external affairs, I don't see it.
Okay. Even on the review of the Iranian potential agreement with Iran?
Well, we do have a bipartisan position from Senate Foreign Relations, very, very, very good.
It doesn't project. So,
Yeah,
for that, yeah. Good. You're a tech guy. Thanks. Yeah, right.
So we do have on the agreement with Iran, the administration was taking the position that it can do this unilaterally, that Congress has no role at all. And there was a completely unanimous bipartisan position that made the administration back off. And I think, very complex study, but subject, but this is an agreement that's going to go for 10, 15 years longer. And I think that agreement is stronger when the two branches work together instead of it being part of Obama's legacy. And it's always concerned that you're trying to do something not for the national interest because you're 6 years up till now haven't been too pretty a story. So no, I think the two branches need to be part of this.
So why has Congress failed? Is it because of this extreme partisanship, they can't get the votes, or why? Why have they failed to check the president from Truman on? Yeah, they were the communists, okay,
About a month ago, I went down to Clemson. I took with me some congressional records I get at my house, and I read the House debate on the sex trafficking bill. And it was extraordinarily bipartisan, huge majorities. The House had passed this a year ago. The Senate never acted. But it was first rate. Members from those areas where children, 12, 13 years old, are brought into sex trafficking, Houston and other areas. So Congress can do it, and I don't think the newspapers pay much attention when Congress does act in a bipartisan way.
Well, another one right now that's blossoming, it may or may not go forward in the House, is the TPA, the Trade Promotion Authority, which is the first step before TPP, the trade. And it looks like they're within 30 votes of the House of having a bipartisan agreement there, too.
But it looks like the opposition is coming from Democrats, right?
Yeah, far left, union, environmentalists, human rights people. I guess it gets back to the point that when you have a highly polarized Congress, is it almost impossible to check the president on war powers? When you have this not bipartisan.
It's certainly
but
difficult.
partisan.
I mean, it did happen. The one thing I'll say is it did sort of happen in Syria, and that's at least one hopeful example. But of course, it's very difficult. And what I noticed too is, so you're right. Of course, the polarization, the party identification. Democrats will often side with Obama, Republicans with Bush when he was in office. What's interesting though is, and this is really strange to me in a way. Maybe there's an answer though. Republicans who are very critical of Obama on some issues, for instance, on domestic issues like immigration, Affordable Care Act, and they say he's a dictator for acting in these areas. On national security, tend to be very deferential. So that's a problem too, I think.
So they're inconsistent, and this professor that taught constitutional law, Professor Obama,
Yeah.
is somewhat inconsistent too, then, isn't he, in terms of his earlier arguments?
Yeah. Oh, yeah.
Well, I just wanted to say that on ISIL, I think there's really fundamental disagreement in Congress about the draft that the president sent forward. So the Democrats are taking the lesson from the 2001 AUMF and wanting to put in more limits. The Republicans don't want a limited, they want to give the president the authority to be able to do what he needs to, what they see as him needing to do what he needs to do against ISIL. So there's just a fundamental disagreement. They
Yes.
want to give the president authority, and the Democrats are worried. And the draft itself is actually kind of clever, because it asks for ISIL-specific authorization, but it never mentions the 2001 AUMF. By never mentioning the 2001 AUMF, which he already claims he has the authority to do what he's already doing, it sort of adds authority on top of continuing authority. So that, so that it's not like limiting his authority, it's just increasing his authority, so that if there is ever if they do pass it, they need to rewrite that, so that the new authorization supersedes the old authorization rather than being on top of it.
So Lou, why has the Office of Legal Counsel been silent on this use of force against ISIS and ISIL?
Okay, one of the odd things this last military action against the Islamic State started last August, and the administration made a number of legal statements about the president's authority. And sometimes it came out of the Defense Department, sometimes it came out of the press secretary, sometimes it came out of senior administration officials. You don't know who they are, but they're giving their views as to the president's authority, legal authority, and not a word from the Justice Department. So I think that what might have happened is that in 2011, the Office of Legal Counsel and the Justice Department put out a memo justifying Obama's military action. And first of all, I thought it was curious that you would put out a legal memo on April 1, April Fool's Day. I would have waited just a little bit. But it's, I think what OLC said back in 2011 is making it difficult for it to speak now. Namely, in 2011, it had to ask, is this war? And there does seem to be a pattern in the executive branch. If it's, quote, war, then Congress has to authorize it. And if you can get away from not calling it war, something else like a UN police action, you do that. And that's the pattern too. You don't call it war. But what OLC said in determining whether it's war or not, reason that, quote, a planned military engagement that constitutes a war within the meaning of the Declaration of War Clause may require prior congressional authorization. Then you have to look at the anticipated nature, scope, and duration. And then OLC says meeting the standard of war is satisfied only, quote, by prolonged and substantial military engagements typically involving exposure of U.S. military personnel to significant risk over a significant, well, that's what we have right now since August. Even the administration said this is going to last 3 years or more into the next administration. So I think OLC is also in a very difficult spot because although it initially supported Obama in 2011 on Libya, Obama, I don't know why he has to speak as much as he does. I guess presidents do that, but he said with regard to Libya, this will be a matter of days, not weeks. It lasted 7 months. And once you start going from 30 days to 60 days, you start triggering the War Powers Resolution, which seems to give a little bit of a green light to presidential actions for 60 up to 90 days. So then the OLC was asked by the Obama administration, give us a memo that says that what's going on in Libya doesn't constitute, quote, hostilities, because if it's not hostilities, the War Powers Resolution doesn't apply. And amazingly, OLC refused to release such a memo. Then they went to Jay Johnson, who's, of course, Secretary of Homeland Security now, but then he was the General Counsel in the Defense Department, and he wouldn't do it either. He says, you're sending in drones, you're sending in planes, you're sending in all kind of firepower. He wouldn't do it. So, of course, they got 2 other people, and Chris has written about some of the people who said there's no hostility. So, pretty absurd. So that's the background on OLC, and I think it's not playing any leadership role now at all on legal matters. Quite amazing.
Shoon, drones were mentioned. I know that you've written about drones. They've been used in Pakistan, they've been used in Afghanistan, but also in Yemen. And we, as I mentioned before, killed a U.S. citizen with a drone without a trial in Yemen. Now, does this get us into a whole nother dimension of presidential power when it was reported that he was actually sitting there making decisions about targeting drones? I mean, has this expanded his power even more?
Well, it comes right back to the 2001 AUMF, because with that authorization, essentially Congress was saying that we are in a conflict with a group, and that group is not necessarily on, it's not a nation in one territory, but in various places. And the administration then uses that as a rationale for lethal targeting. And drones is just another, the legal part of it is just, it's not the technology of drones, it's the lethal targeting, which the United States does not have a history of. This is something that, we forget how new this is. This is a war framework that comes right after 9/11. There were times when the president would do this before. There were, Clinton used airstrikes against, Al-Qaeda in Afghanistan and supposedly in Sudan in 1998. But this was not routine lethal targeting. And it really happens after 9/11, starting with Bush. He has a kill list of 24. That expands with drone technology to targeting in Pakistan in a much less discriminate way, signature strikes, not even knowing who you're targeting, but targeting by signature behaviors. Obama, he inherits that authorization and expands it, because his point of view is that this is much more surgical than land wars in Iraq and Afghanistan. This is a smart way to go after counterterrorism, but he enhances it enormously, 7 times the drone strikes in Pakistan, and he's responsible for all but one of the drone strikes in Yemen. And it's all based on the idea that this is an armed conflict, which is challenged by others. So the Europeans question this. Human rights groups question this. They question the idea that one is the intensity really that of an armed conflict under international law? And does a country have the right to use military force in areas that are not battlegrounds? These are, and if you look at international public opinion, most people are strongly against this. Americans aren't. Americans support it, unless it's an American.
They support it, they just don't have attitudes about it.
No, they have attitudes and they support it, but they change the view if it's an American, which raises the question of the killing of Anwar al-Awlaki, and the justification for that. And the justification given was that it's legal, and that Eric Holder said that you don't even have to have constitutional due process does not mean necessarily judicial review. It's also worthy of noting that Obama came out with late. He came out with targeting guidelines, that narrowed the conditions when the United States could use drones. But to my mind, if you think about how short a history this is, and that a president can decide who to kill in other countries, can kill an American in other countries, can come up with their own self-designed guidelines, can do it by their own interpretation of the 2001 AUMF, without review by Congress and without review by the courts. To me, this is an enormous expansion of executive power.
Good, thank you. Let's open it up to the audience, and please tell us who you are and ask the question. We have plenty of time for Q&A. I don't know how we're going to handle the sound on the questions. Maybe we should just repeat the question, because I'm not sure you're going to get picked up. Right.
So my name is Donna Dalen, and I'd like to thank you. It's very interesting, but I'd like to play devil's advocate for a moment and put the question to you this way. The framers came up with a great system in 1787, but they didn't anticipate weapons of mass destruction and rice and SAR and using airplanes as a weapon. So they also didn't anticipate a legislative branch that would be so gridlocked and unable to act. If you look at this Congress and the previous Congress, they don't seem to get too much done. In light of all that, maybe we're all better off when the executive branch steps in and does something, because if we wait for Congress to do something, we may all grow old.
So let's repeat the question. It is, we can't wait for Godot because there's lots of technology and the threats are very different and we've got gridlock, right? Is that it?
Chris and I have talked about this for a long, long, long time. And my attitude is that the framers, 18th century, were not talking about details such as drones and atomic bombs. They were talking about human nature. And they had watched around the world over a long period of time how nations go to war, and they did it with single executives, princes, kings, you name it. And the results were not good for the country. These were judgments made by single executives, not for the national interest, but for personal interest, for family interest, for party interest, and so forth. And the result was impoverishing the nation on lives lost and fortunes squandered. So I think someone would have to make a case that human nature has changed, that single executives are better today. And I think the evidence is that the framers had it right, that you have Truman on his own getting involved in Korea, a calamity for him, his party, and for U.S. soldiers and for Koreans. Maybe more than 1 million people in Korea died on what led to a stalemate. Lyndon Johnson single-handedly escalated the war in Vietnam, calamity for him, his party, for the nation, and for Southeast Asia. We have other people single-handedly doing things. George W. Bush, interestingly, came to Congress both times for Afghanistan and Iraq to get authority. But as we know, the evidence from a single executive on Iraq, 6 claims of weapons of mass destruction, all of them empty. So no, I don't think there's any reason at all to believe anything a single executive says on why it's in the nation's interest to go to war.
Wait a minute. You claim that human nature hasn't changed, but we have structures to limit human structures. We don't have Peter the Great. We don't have Stalin. We don't have Hitler in this democracy. We have ways of limiting that power, right?
No, but
Changing behavior.
the framer says do not leave it to a single executive, and I think their judgment is correct and even more necessary today.
And let me make a point on that too. So Jim, just to quickly say, what Jim's pointing out is you have this structure of checks and balances in place. The problem is it's not being followed. Have people heard of the unitary executive theory before? I know some people here have. When I first explained this to an editor, they didn't believe it. The unitary executive theory is the idea that the president can set aside laws that infringe on executive authority. The president's above the law. It's basically the British model the framers rejected. So Jim's absolutely right. There's a structure in place. The problem is it's not being followed. And part of it, as Don and as Jim mentioned before too, is the system depends on each institution asserting its power, and that's not happening. And it's a hard question. I don't know for sure the answer to that.
Let's go to Brad. You have a question, Brad.
You mentioned other institutions that we haven't heard from yet. You're talking about the president and the Congress.
Mm-hmm.
Well, ask, let us look at the judiciary.
Right.
And I'm wondering why the Supreme Court seems to be so hesitant about looking at Article 2 and making a decision. Now, you remember in the Handy case, it came out of the Fourth Circuit in the Carolinas, and the Fourth Circuit said, in effect, Article 2, well, let's put this guy Handy in jail. And that case went to the Supreme Court, and I thought to myself, well, now maybe with the Fourth Circuit relying on Article 2, the Supreme Court may say something about this. And what happened? The Supreme Court said, we do not reach
They dodged
Article
it, yeah.
2. Why don't they reach it more and use it? And I've written a question out for Lou. Would there ever be, has there ever been a case that has come where the Supreme Court would say, well, if the President of the United States, who under Article 2 is the Commander-in-Chief of the Army and Navy, if he uses his Army and Navy military force, what kinds of limits does the first sentence of Article 2, the executive power which is vested in the President, what do we say about the executive power used by the President in the military sense, if you have an actual case where
Yeah.
Article 2 is involved.
Yeah.
There
is.
Let Lou start, and maybe you read the question.
They seem to be scared of discussing Article 2.
There is a case.
See if I can read Brad's handwriting. When he employs the military force of the Army and Navy, of which Article 2 makes him Commander-in-Chief, the President's Article 2 executive power is, and would like an answer to that. I would say with regard to the judiciary, and I'm glad you brought it up, the judiciary has been a large part of the problem because they either defer to the executive, as with the Japanese-American cases in World War II, or they put in erroneous information into a decision which magnifies presidential power. Now, you may be shocked that I could say the Supreme Court puts erroneous information into a decision. Well, I will take the authority of Chief Justice Rehnquist, and one of his decisions said that the Supreme Court, as with any human institution, is fallible. That's a tough one, isn't it? So in 1936, some of you know about the Curtis Wright case. All it had to do was legislative power, had nothing to do with presidential power. But by the time it comes out of the Supreme Court, Justice Sutherland, who'd been a senator for 12 years, throws in extraneous stuff, we call it dicta, and it's erroneous because he said that John Marshall in 1800 said the president is the sole organ in external affairs. Sole organ, sole, that sounds clear, exclusive, plenary, sole organ, what's organ? Well, I hope any student knows that the only way you can figure out what John Marshall meant, who the next year would be Chief Justice of the Supreme Court, the only way is to read the speech. And there's no evidence that Sutherland has read it or any judge or law clerk has read it. And if you read it, I teach a class at the William & Mary Law School, and my students read it, and they say, Sutherland's wrong, obviously wrong, that you cannot say the president has plenary exclusive power in external affairs. If you read Article 1, look at all the things that are given to Congress. So that's stupid. And yet, although that was closely dicta, over time, dicta becomes the holding. No one cites Curtis Wright for the delegation issue. They cite it for the sole organ doctrine. And it's right before the Supreme Court today, and within the next few weeks, we may get a decision. And Chris said I wrote an annoying amicus brief last year telling the court, you made a mistake in 1936, fix it. And they're going to do one of two things. One, they'll fix it, which would be interesting. You have an error sitting around from 1936 and finally gets corrected in 2015. Or, much, much more likely, they won't do anything. And I'll just say, what other profession operates that way? Do doctors make a mistake in 1936? Do engineers make a mistake? Buildings keep falling down? No, other professions don't do that. But our legal profession functions that way.
So now you can see.
In his Hamdi decision, Justice Thomas used that old
Yes.
mistake again in his opinion.
Jim, can I quickly say something about
Yeah, sure.
So you asked, has the court ever taken on this question of Article 2 authority? In Youngstown Sheet, yes. In the Youngstown Sheet case, President Truman made this argument, basically the unitary executive argument, just they didn't call it then in the 1950s. Youngstown Sheet, it was a steel seizure case. During the Korean War, President Truman, who had begun an illegal war, said during the course of fighting this illegal war, there's a strike that's about to happen in the steel industry. I have to take control of the steel factories. Right. And he claimed he had this emergency power, inherent power under Article 2 as Commander-in-Chief. The Supreme Court said no. Justice Jackson's concurring opinion said, we rejected that model. The president, he said this is a really dangerous example. In fact, Jackson cited the Hitler example. He wasn't saying Truman was Hitler, but he said once we start giving the president this kind of emergency power, it's very dangerous. That's, I think, the best example of the court taking it on. In Hamdi, you're right. They dodge it. And I think the reason why they dodge it in cases like Hamdi, it's clear that Justice O'Connor, writing the plurality opinion in Hamdi, wanted to be balanced. She said, there's a line in the case that's famous. She says, a state of war is not a blank check for the president. Well, that sounds good. But then she says, oh, the president's making these claims about inherent authority. I'm not going to decide that. She clearly wanted to be measured. The opinion begins, as all the post-9/11 opinions begin, by saying September 11th was terrible, which clearly it was, and we are going to take that into account. And she wanted to be clear, I'm not trying to infringe too much on the president's power, and I think that's why she was careful not to go too far with her opinion. I agree with you. I would have liked the court to squarely have repudiated this idea of inherent authority.
Let's go here.
Philip Renner, School of International Service. First, it's a pleasure to have this one. Lou Fisher is one of my heroes. And just to add to your answer, which I guess I learned from your books, is that another problem with Justice Sutherland's over the dictum is that it claims that there's an inherent nature to the executive to make foreign policy. And you point out very well that when the United States first became the United States, we had a continental Congress that made foreign policy. We didn't have an executive. So it's flawed in history as well. So let me take also a kind of devil's advocate stance. Stephen Ratner on Saturday had a very interesting op-ed in the New York Times arguing the position, the woman over there argued that we need a strong president. And what is somewhat unstated in that is that the United States has what might be called an imperial policy. And Arthur Schlesinger, in his last book on war, powers, and the president, said that in rethinking the notion of the imperial presidency, it really is about a president who is imperial when he's leading an empire. It's very hard to have a Congress that's involved in making imperial policy because you have to do nasty things like use drones. Of course, in the case of the drones, we only killed bad people. But we might not. It might be an instance where we might not kill that person. So I think that's the underlying problem. And in part, the American people have been, I would say, a little bit led astray or sometimes confused. But when they focus clearly on what U.S. foreign policy is about, they reject it. And that's when the Congress says, oops, we better come into the and play a role because our constituents don't like this, which is what I think happened in the case of Syria. But when it's not so clear, when we're fighting for freedom and there are clear good guys and bad guys, then the American people do go along with the president, and the Congress it doesn't know what to do about this because there are some members of Congress who do oppose an imperial policy. So how do I fit that kind of analysis into what you're talking about? Yours is an institutional analysis. We're trying to understand the nature of U.S. policy as it affects this.
Yeah, I like the question very much because I think what we've been doing in the academic world is to miseducate students and the nation. And what we've done, and there's a long pattern of this, starting around 1950s and 1960s, presidential scholars idealized the president, and Arthur Schlesinger was part of that with his books on Jackson and FDR and John Kennedy. But there are other, all the major academics at the time, Richard Neustadt, Clinton Rossiter, James McGregor Burns, they all went 100% on the side of the president, and not only 100%, but totally threw away law in the Constitution. That law and politics and political science used to be like that. You couldn't separate them. But we have gone away because of the behavioralism in the 1950s and on. So we do idealize the president. We do idealize the Supreme Court. These are smart cookies. They never make a mistake. They would never make an error. And if they ever did, they'd fix it right away. No, we idealize them. And the one branch we don't idealize is Congress. We're very realistic about Congress. And I think one of the amazing things, I'm writing a book on it, I've done in the past, but I have a book with a stupid title. It's called Congress, Protecting Individual Rights. I mean, you've got to be joking. But in fact, if you look over more than 2 centuries, the branch that has protected individual rights and minority rights, blacks, women, children, etc., has been Congress. They make mistakes, of course, but their record is far, far better than the other 2 branches, and they never get credit for it.
Shoon would like to say a word to this, if you don't mind.
Oh, yes, yes.
I don't know that I would put it into an imperial Yeah. Certainly, public opinion matters, and I think public opinion is different for different types of military interventions. Humanitarian interventions tend to be the kind of, like in Libya, tend to be the kind of interventions that the public does not support as much. Questions about terrorism are very emotional, and the public tends to support it, at least from the air. But public support matters. It does in giving the Congress the backbone to challenge the president. But I don't think you need the big framework in order to get there.
No, but Shoon, given the nature of U.S. policy, presidential policy is really about having an engaged United States intervening, being a world policeman. That's what we're really talking about. Because U.S. interests, the president extended in Libya to say U.S. interests involved our fundamental values. Well, maybe, but that gives him such a broad spectrum that then he becomes a tyrant. So the question is, what about U.S. foreign policy in this Sunday rules?
So that's a good question to segue to the next question.
Okay.
Mike?
Such a good moderator.
My name is Mike Measley. I think the panel was absolutely right on the intent of the framers, obviously, of the Constitution and legal question. I think it's a little unfair to hold President Obama's campaign comments against him. I always think of the famous quote that everybody believes in democracy until they become president. So I'm sure that we'll find other presidents who made similar comments when they were campaigning. Obama said the same thing about signing statements.
Yes.
And all that stuff. We've had very little mention almost of the War Powers Resolution, at a time when, and I think of this because the panel is suggesting, where's Congress's backbone? Well, here we are in 73, 74, presidential power is in its nadir, yet post-Vietnam period, Congress, with a huge bipartisan majority, passes the War Powers Resolution over the override.
Over Nixon's veto, yeah.
And now we see over the last 40 years, it doesn't mean very much, the War Powers Resolution. The presidency essentially said, look, we're not going to pay too much attention to this. We will talk to Congress and say, in the spirit of the War Powers Resolution, but not actually conforming to the War Powers Resolution. What exactly is Congress supposed to do? Is really, as Fisher and Jones suggest, to impeach a president? That sounds like the answer, because we know the courts aren't going to do anything about this sort of issue. Is the president simply going to say, if Congress tries to assert its authority, we're just going to ignore it?
Do you want to
Sure.
Yeah.
Lou?
I would give the Supreme Court credit after 9/11 for its decisions because it did push back. In Hamdi,
Individual issues.
on Hamdan, it struck down Bush's claim he has inherent authority to create military tribunals, Razul. And I think one reason the Supreme Court pushed back that in April 2004, there's oral argument on the Padilla and what was the other case then? But the justices, probably Hamdi, and the justices were asking Paul Clement, who was the acting Solicitor General, maybe, do we torture? No, we don't torture, he said. We don't torture. Well, do we torture? No, we don't torture because you don't get good information. Do we torture? No, we'd prosecute people on it. Over and over and over again. That evening, you know what went around the world. Photos of Abu Ghraib. So I think the Supreme Court said, we're dealing with an executive branch here that doesn't know what it's doing. I mean, Clement obviously didn't know what's going on in the Justice Department. So I think the court did do it well. what are some other things I'll talk about later on?
Well, I'll just rip off Lou here because he's written about this. I mean, the problem, the War Powers Resolution, clearly the intent, Lou talked about, is to limit presidential power. It was the bombing of Cambodia, which Lou points out is called the secret bombing. It wasn't secret to the Cambodians, but it was secret to Congress. Congress found out about this and they said, wait a second, we want to make sure that there are limits on presidential power. In some extraordinary circumstances, if the United States is attacked or imminent attack, you can use military force, but even then, just up to 60 days before you get approval. Problem is, the statute's not well drafted. It's ambiguous. It's clear what they intended, but they wrote it, unfortunately, not in the clearest way. And presidents are all too willing to take advantage of that in the same kind of ways that Shoon talks about with the 2001 AUMF. Most recently, and I think, unfortunately, most ludicrously, Harold Koh with the in Libya. The OLC, as Lou mentioned before, was actually going. They said the War Powers Resolution, we're going to stretch it, but we're not going to completely disregard it. It has to mean something. After 60 days, sorry, President Obama, you have to go get approval from Congress. They asserted themselves, which I think was good. But then President Obama says, well, what about you, Harold Koh? You have this background of being concerned about checks and balances. Do you still feel that way? No, now he doesn't. He's in the executive branch, and what he says is, actually, you know what? Not only are these sorties and bombs being dropped in Libya, not only is that not war, it's not even hostility as under the War Powers Resolution, so you can actually do whatever you want. It's a ludicrous result. As Lou mentioned, I think in testimony to the Senate, as well as in an article, Lou said if that's the standard, that you can, as long as you're not using ground troops, it's not hostilities, that means the United States could pulverize another country without Congress being involved. So yes, it's the same story of presidents overreading, misreading, stretching statutory authority, and unfortunately, for the War Powers Resolution to really work, as you mentioned, courts aren't enforcing this. That's right. And Congress could, though. Congress could say, wait a second, we don't agree with this. On Libya, some members of Congress did, but not enough to actually take action. So it really, in my view, it does come down to Congress has to assert itself. Congress has to play the role that Jim mentioned in the context of checks and balances. If they don't work, if they don't do that, no statute will work.
The point is, though, Congress will insert itself. The presidents, I remember that when Bush went to Congress about Iraq, he made it quite clear that whether Congress voted yes or no, he was going to go ahead.
Obama said that in Syria, too.
Iraq,
So it goes to Lou's point. So if I was really intrigued on Syria, I mean, intrigued in kind of a weird sort of surreal way, President Obama went to Congress and he said, I'm going to you to ask, this is good to get approval, but if you don't approve, I still reserve the authority to act. So I was thinking in my head, wow, if Congress says no and he acts anyways, what happens? It's a constitutional crisis. And then it just becomes a question, will Congress actually impeach? Fortunately, that didn't happen. But that to me, yeah, it's an interesting question.
Let's go in the far back, please.
Christian Maish, I teach in the Washington semester program of the School of Professional and Islamic Studies. And first of all, I want to thank all of the panelists. This is a great panel, and it's an important, very important topic. I also want to second the point that Professor Phil Brenner made about the fact that it is very difficult to have a democratic system and at the same time pursue an imperialist foreign policy. There is an inconsistency there. And when we see the expansionist policy of the United States after World War II, we also see the concentration of power in the executive branch within the constitutional system. But now that this issue has been raised about declaring all of these military actions not acts of war, I'm also thinking about the implications in terms of international law and questions of crimes against humanity, war crimes, illegal behavior. Because if this is not a war, what is this, and how are we going to regulate the killing of civilians in actions that are now considered by the executive non-war acts in order to get around Congress?
Chris, would you like to take that on?
On the seat? Yeah,
I'll say a word and then pass it to you.
Oh, please, go ahead.
That's the contention that Europeans have, for instance, with the way that the United States looks at the 2001 AUMF as saying that they're in an armed conflict. If you're not in an armed conflict, then lethal targeting is assassination. If you're not in an armed conflict, then capture is kidnapping. So that it really depends upon that interpretation. And in 2014, for instance, the European Parliament overwhelmingly condemned the use of drone strikes because it's a different they're not in the war framework.
Yeah, I think the president's. Oh, sorry.
No, I just said thank you.
Oh, yes. Since September 11th, American presidents have tried to have it both ways. When it helps them, they want to call it war because then it authorizes. Then it's not assassination, it's not kidnapping. But then there was a memo written in November 2001 where Patrick Philbin said, but none of those protections apply to people we captured. So, which was, I think, an incorrect conclusion, and actually was wrong as a matter of law. The Geneva Conventions, what his point was, is that terrorists don't abide by the laws of war, so they have no protections under the Geneva Conventions. Common Article 3 of the Geneva Conventions applies to anyone who's captured, so I think he was wrong about that. Another quick point, there's news today about in January, there was a drone strike, or drone strikes, it sounds like, in Afghanistan and Pakistan. U.S. citizen was killed who was a hostage, an Italian man who was a hostage, and apparently 2 Americans who were members of Al-Qaeda. There are a number of questions about this. One question that's interesting to me is, apparently it was a CIA drone strike, which I think is typically the case. Shoon knows more about this than me, but if it's a CIA drone strike, that may actually be illegal too. The 2001 AUMF says the military can take action. The CIA may not actually be authorized to do this, and that's an interesting question too. But sorry,
Just a quick comment on international law. I do think this country is governed by the U.S. Constitution, not by constitutional law. And I get the sense that European nations are more agreeable on operating under international law. And I think it would be a pity for us to go in that direction because there's enough vagueness out there that I think it would play even more in the hands of the president. We've already seen it with the UN Security Council. So I wouldn't give up on the U.S. Constitution.
Susan.
I hear there's a disconnect going on in my head. I hear you people and your legal analysis of how the president is acting extra-constitutionally. And I'm sort of, not disputing that at all, but when you read the newspapers as the presidential campaign is heating up, all I hear is Obama being criticized for not acting strong enough, for not taking enough military action, for not doing enough to save the country, et cetera, et cetera. So what, is that just political pandering? Is that just rhetoric? How do you explain that disconnect?
Well, you're right. You see it. You certainly see it in the debate over the authorization for ISIL. The Republican stance is that why are you sending us an authorization that has a limit in time and also a limit on ground troops? You should send us. Why are you sending us an authorization that limits the president's power? We don't want to pass this. And the Democrats are saying, why are you sending us an authorization that doesn't sunset the 2001 AUMF? And what is this? You're too vague on the type of military action that could take. You have different points of view, and you're right that the Republicans are criticizing Obama for not doing enough. I still don't think that challenges the constitutional analysis that we're making.
Yes, and let me make a quick point of that. I think that's right. I think it goes to Lou's point, the point Lou made before about idealizing the president. That has taken hold in American society, and I think journalists reflect that, and I think they're not getting the constitutional framework right. They convey this message. We have these problems out there, these really scary things, and ISIL is scary. There are scary things in the world. This one person can solve it, and presidential candidates play into that. Senator Rand Paul, I saw when he announced his candidacy, he said, I'm going to take back America. I'm not sure exactly what that means, first of all, but I'm secondly concerned, no one person can do that. That's someone mentioned before, but candidates make promises and that should be taken into context. Of course, one thing we should learn from President Obama, though, is there are limits on what presidents can do. That's the reality. But people have this idealized notion, as Lou said, and as Lou's written about, and it's really more compatible with the British model the framers rejected. But I think journalists don't convey to the American public, wait a second, this president, you see the president on TV all the time, they seem like they're in charge and doing everything. They're part of a government with checks and balances, and they're not actually, they don't have unlimited power, and they shouldn't.
But embedded in her question is this drive for election and drive for re-election. And when you're out on the campaign trail, sometimes you're not that concerned about the Constitution. And so that you say things that are unconstitutional to get elected because they're really motivated to that. And by the way, Rand Paul, I think he said, we're going to take America back to something. Never mind.
Yeah. One objection I have from Truman up through Obama is presidential claims of what they think is legal and constitutional. And I would say the greatest crisis we ever had in the Civil War, Lincoln never claimed what he did with all of his extraordinary actions was legal and constitutional. He never did that. He finally, of course, he took these actions in April 1861, and we called Congress back in July 4, 1861. He explained what he did, and then he said whether strictly legal or not, that's a kind of a cute phrase, whether strictly legal or not. But then this is a magnificent statement. He said, I don't think I did anything beyond the, quote, constitutional competency of Congress. He's saying flat out, I used Article I power, and the only way what I did can be made legal is if you consider what I did and pass retroactive authorization. That's clean language, and presidents haven't done it from 1950 on.
Another question from someone. Yes, sir.
Yeah, I'm Jay Morgan. I'm a former student of Professor Edelson. I think part of the problem is congressional review of presidential actions is inherently more political than judicial review. Not that the Supreme Court isn't a political institution, but I'm thinking particularly about Guantanamo, because Congress was pretty differential when Bush unilaterally established it, but now won't let Obama unilaterally abolish it. And this point's been raised a couple times by Professor Fisher talking about the Japanese internment. When you have either the president and Congress either one stopping the other from ceasing an unconstitutional action or working together in performing an unconstitutional action, are there any really effective institutional recourses that in the constitutional framework? I know, like, with examples of Korematsu or Ex parte Milligan, the excuse is, well, these actions were unconstitutional, but they were temporary because of the crisis that was at hand, be it Civil War or World War II. But with the current context, ever since the Cold War and the War on Terror, it seems to be an era of enduring crisis. So at what point does that excuse sort of fade away, and how do we confront that within an institutional context?
So, Lou, I want to point out that we teach our students here very well.
Let me, I'm just wondering, you have some comments, I'll collect mine a little bit.
Yeah, so wait, just to make sure I understand, Jay.
Sure.
So you're saying, I think you're right about this. One of the problems, in some ways what's happened since September 11th is a continuation. Presidents have done this before. One thing that's different, though, although the Cold War had this element too, is this emergency is ongoing. And you're saying, given it's an ongoing emergency, how do you check power in that context? Is that your...
Yes, and also that since Congress is also more political than the Supreme Court, the judicial branch, that political concerns will trump legal concerns in
excellent point.
review of
Great point.
judicial action.
Yes, I've thought about that. I think politics and law are often separated out. They really, as Lou mentioned before, they really overlap. I mean, political. If Congress was making, you could call it a political case against the war against Syria in 2013, but it was grounded in constitutional concerns. It was a political case because their constituents were saying, we don't want this, but they expressed it as a constitutional argument. So even if Congress is motivated by political concerns, I would argue as long as the debate is couched in constitutional terms, you can still have a good debate. Congress can be motivated by whatever, its constituents, it doesn't like President Obama, it thinks it's a dictator. As long as you have an argument in constitutional terms, you can sort out, the public observing it, other members of Congress, people in the executive branch, can sort out whether the argument makes sense or not. So I don't think the fact that Congress is political and may be more political than the Supreme Court, although as you said, of course, the court has political motivations too, I don't see that as an inherent problem. I think it's still a question of, okay, how is it presenting its arguments? Is it making good arguments? This applies to all the branches of government. When the president says I can act, how is he justifying that? When Congress says the president has gone too far, how is he justifying that? I think that's not an insuperable problem, but others want to weigh in.
Yeah, you started off talking about Guantanamo. So here you have President Obama, his second full day in office, January 22, 2009. signs an executive order to close Guantanamo within a year. There should have been some adult in the room to say, excuse me, Mr. President, you can't close Guantanamo unless you have a facility in the United States, and that'll cost about $100 million, and you need an appropriation from Congress. You have to do it jointly. So he gets out, I mean, that's just right from the start. We're kind of kids here. We don't know what's going on. I mean, how can you do that? And I'm worried, not just
He
about...
was trying to change the way Washington works.
Oh, that worked. I know, it worked very well. But I'm as worried about presidents as I am about the lack of people around presidents to say, this is stupid. You can't do that. You'll look like a fool, Mr. President. And it's not done.
Yes, it's not done. Although it's interesting to note, though, Congress did put limits on what the president can do, but hasn't prevented transfers. And President Obama took office, about 240 people at Guantanamo. It's down to about 120 now, so people are being transferred.
But right now, the Pentagon's trying to transfer as many as they can
Yep.
before Congress
Correct.
stops it.
Sure.
Yes,
entirely.
you're right. You're right.
So I want to ask a very personal question, mainly of Lou, but all of you. You've all appeared before congressional committees. Lou was one of the senior scholars at CRS. I think there are 10 left. There were 23 at one point. It's a very distinguished position.
How about going from 18 to 3?
18 to 3. And you were hard-hitting up there in terms of writing CRS memos for individuals and committees, and sometimes people didn't like it. So what kind of pressure was brought upon you at that institution that's supposed to be on the one hand, on the other hand, and you clearly showed that there's not two hands on some of these arguments?
You know, not just me, but other senior people who testified, we were asked for our positions, and our positions were on paper and went through front office clearance, and we gave positions. We didn't say there's 6 here and 6 there and you got any questions. No, we took positions, and that was Congress, when it created Congressional Research Service and authorized senior specialists. We're asking for that kind of advice at that level, just the highest level in the executive branch. So somehow we have a new administrator who came up with this notion that CRS, when we say something, has to be neutral. Well, you can't do research that way. What's that? Meaningless. You know, you do all that research and then you're neutral. So something has changed fundamentally. And even I retired about 4 years ago. Even today, there are people who don't write on the outside, publish on the outside the way they used to. They are very, very circumspect, and that's a pity because you're supposed to give it. I've never, in all that time, never heard any member complain that I took that position. I should have taken that one. I took it. I've taken this position for these reasons, and that's all they wanted. That's all they wanted.
It's a great loss, in my opinion, that is not possible now at CRS.
Yeah.
Right. One last question before some of you students take those box lunches home for dinner. So another question, one last question. Would you like to summarize with any remarks and add to this anything that you haven't reflected upon?
No, just that it was a pleasure to share this panel with the two of you. It was fun. Thank you.
I really enjoyed it too. Thanks very much.
Great time. Very great questions. Thank you very much.
Thank you.